Hello, everyone. Today I'm going to be talking about competency to consent to a search and seizure. So, Chapter 7 was the chapter I pulled my information from, other competencies in the criminal process. Competency to consent to a search and seizure is a decisional competency. So, the individual has the ability to make a particular decision. Um, Parens patre, probably butchered that. Ultimately translates to state as parent, which means that the state can make the decision for the individual when the person lacks the ability to make a specific decision or perform a specific act. If the individual can do those things, then the state keeps it in the individual's hands. The Fourth Amendment is a big part of my section of information. And the Fourth Amendment really talks about how it prohibits unreasonable search and seizures, and it's based on probable cause, the search and seizures are. And it can also, when voluntary consent is given, can also make a search reasonable. The police can't search an individual's property without probable cause, and they have to have a reason for the search. Again, when voluntary consent is given, that is a way to make a search a reasonable search. There was some research in the reading as well. The first one was simulated search scenarios, and it was mainly based off of being requested to search the individual's property. And the way that the police phrased these requests really put weight on if the individual will be more likely to give consent without much pushback. So the first example and how they phrased it was interrogatory, which would be, would you mind if I came in and looked around? As opposed of declarative, which is, I would appreciate it if I could come in and look around. So with the first phrasing, people were more likely to give their consent without much question. Also, if the cops gave more information up front, there was less likelihood that there would be pushback after the consent had been given, as in the individual would not ask the police to leave after they gave their consent. With the second research, they interviewed with 54 people. Those were actually confronted by the police. And what they found out is that fear played a major role in the decision making. Primarily, the individuals were fearful of what would happen if they did not give their consent. And instead of finding out, I guess, they gave their consent. Few of these individuals that are interviewed knew that they had the right to refuse. But even having that knowledge, they were fearful that the law would not be followed by the police. So they gave their consent anyways, because they did not have faith in the law. The video I chose was a crash course video. I love these videos. They're very informative and they really help break down the information that they're talking about. So in this video, they're talking about the Fourth Amendment, really breaking that down, really explaining search and seizures and what probable cause is and what a reasonable search is as well. My discussion question, should the knowledge of the right to refuse be a secondary issue? In my reading, that came across when the competency and the knowledge came into question. And it doesn't really, the knowledge, whether or not the individual has that knowledge, doesn't really play a factor, which begs to question, do they have the competency to even make the decision if they don't have the knowledge? How can you be competent in something if you aren't um aware of all of the information and having all of that knowledge to make an informative decision. So I figure that would be a really interesting discussion question to throw in there.